Marcus had been with the company for 6 years. Good worker, never caused problems. Then one afternoon, a pallet shifted wrong. He reached out to catch it and he tore up his shoulder. HR came to him the very next morning. He was still in the hospital, clipboard in hand. They said, "We just need a quick recorded statement. It's standard, totally routine." Marcus figured, why not? He had nothing to hide. He answered every question. He was honest. He was polite. And 2 months later, when he tried to pursue his workplace injury claim in Texas, that routine statement had become a weapon aimed directly at him. I've been handling workplace injury cases in Texas for over 28 years, and I can tell you that story is not unusual. In fact, it's one of the most common mistakes I see injured workers make in the very first 24 hours after getting hurt. So let's talk about what's actually happening when someone asks for that statement, why it's dangerous, and what you should do instead. Why non-subscriber employers move fast. The first thing you need to understand is that Texas is different from almost every other state. Here, employers are not required to carry workers' compensation insurance. Some do. A lot of them, especially larger companies, opt out. They're called non-subscribers. Now, why does that matter for a recorded statement? Because when a company doesn't have workers' comp, an injured worker can file a civil lawsuit directly against the employer. And in a lawsuit, the employer generally can't use the traditional workers' comp defenses. Things like contributory negligence, assumption of risk. Those defenses are severely limited when a company chooses not to carry workers' comp. That means the employer has real legal exposure, and they know it. So the moment you're injured, the clock starts ticking for them. They want to get in front of you before you talk to a lawyer, before you understand your rights, before the story is locked in on your terms. When I worked on the defense side earlier in my career, I watched insurance adjusters get dispatched to hospital rooms. I watched HR managers get coached by outside counsel on exactly what questions to ask. That urgency isn't about helping you. It's about protecting the company. What a recorded statement actually is. Here's what a lot of people don't realize. A recorded statement isn't an internal HR form that goes into a file somewhere. It gets handed directly to the claims adjuster or the defense attorney. It's recorded, it's transcribed, and it becomes a permanent piece of evidence. Every single thing you say in that statement can be used against you later to challenge your credibility, to suggest your injuries aren't as serious as you claim, or to find inconsistencies between what you said on day 2 and what your doctor wrote in your records 6 weeks later. And here's the critical thing. You are not required to give one, especially not before you've had a chance to speak with an attorney. The employer or their insurance company may pressure you. They may tell you it's required. They may tell you it could delay your claim. Don't believe it. Ask them to put that requirement in writing and watch how quickly the urgency fades. The 5 things they're listening for. Let me walk you through the 5 things the adjuster is specifically trying to capture in that recording. Number 1, prior injuries. They will ask you if you've ever hurt that body part before. If you say yes, even if it was a minor strain years ago that healed completely, they will use it to argue your injury is pre-existing and not their responsibility. Number 2, inconsistencies in your accident account. You're in pain, maybe on medication. You haven't slept. You might describe the accident slightly differently than you described it to the ER nurse. They'll find that difference and amplify it. Number 3, admissions of fault or shared blame. Questions like, were you following all the safety procedures at the time? Or did you have the proper equipment? Those are not safety reviews. They're looking for language that they can use to argue you contributed to your own injury. Number 4, gaps in treatment. If you waited 2 days before going to the doctor, they'll argue the injury must not have been serious. If you missed a follow-up appointment, they'll question your credibility. Number 5, minimizing language. In my experience, this is one of the catches people the most off guard. When someone's trying to come across as tough or not dramatic, they'll say things like, "It's not that bad," or "I just felt a pop." That language ends up in the record, and later, when you're explaining to a jury that you can't raise your arm above your shoulder, they'll read that statement back. The mistakes that sink claims. Beyond those 5 traps, there are a few specific behaviors I've seen repeatedly sink otherwise solid claims. The first is estimating instead of saying, "I don't know." If the adjuster asks, "How fast were you moving when you slipped?" and you don't know exactly, say so. Don't estimate. Estimates get treated as admissions. The second is being too cooperative. Injured workers are often genuinely good people who don't want to cause trouble. They answer more than what was asked. They try to fill the silences. Every extra sentence is another opportunity for a problem. The third is answering questions about your current pain level or future prognosis before you finish treatment. If you're asked, "How do you feel now?" and you say, "A little better," that gets used to argue you've recovered. You don't know that yet. No one does. And the fourth is failing to note inconsistencies at the time. If the adjuster says something inaccurate during the call and you don't correct it, that silence can be treated as an agreement. What you should do instead. So let's talk about what you should actually do. First, decline politely. You don't need to be confrontational. You can simply say, "I'd like to speak with an attorney before giving any recorded statement." That's it. You don't owe them any explanation. Second, write down your own account immediately. Not for them, for you. While your memory is fresh, write down what happened, where you were, what you were doing, what went wrong, who was nearby, what you said to whom. Keep that somewhere safe. If your case ever proceeds, that contemporaneous account can be invaluable. Third, get medical treatment first. Your health is the priority, and your medical records are the foundation of your claim. The consistency between what you tell your doctors and what you later tell attorneys in courts matters more than almost anything else. In 28 years of handling these cases, I've seen strong claims fall apart over recorded statements given in the first 48 hours. I've also seen injured workers protect themselves and their cases simply by doing one thing: pausing before they spoke. If you're watching this because you or someone you know just got hurt at work in Texas, I hope this gave you some clarity on what's actually happening behind the routine request. If you found this helpful, the next video I'd watch is the one on arbitration agreements, because often, right around the same time they ask you for a recorded statement, they'll slide other paperwork in front of you too. That video will tell you exactly what to look for. And if you're already dealing with this situation and you want to talk to someone, our number is in the description below. We're happy to have a conversation.